Good evening. We're so glad that you joined us tonight. And welcome to PCCA's COVID-19 member briefing for March 30th. My name is Ethan Shinogle, and I'm the Director of Marketing here at PCCA. We thank you for being here. For this briefing, we are going to focus in exclusively on the recently passed Families First Coronavirus Response Act, what that means for you, for your pharmacy, for your staff, in the days and the months to come. But before I do, I just want to say thank you. Thank you to all of you. We know that your time is valuable. We appreciate you being here. And whether you're serving rural communities or suburban neighborhoods or major metropolitan areas, you're on the front lines. You're protecting your staff. You're protecting your pharmacies, all so that patients can get the medicine that they need. And we at PCCA appreciate that. We appreciate the opportunity to support you in that mission of serving your patients. And in that, I do want to say that we are reviewing and watching information and questions that are coming in. We're evaluating the situation as it evolves, and our team is making decisions as to whether we're going to have a Monday night briefing each and every week. We want to be judicious with your time, and if we have a week where we do not have necessarily enough information that we believe is beneficial for you, we're going to forego that because we appreciate the trust that you have with us and that we want to honor your time. So with that, I have a few housekeeping items that I'd like to bring to you. Number one, if you have any issues with the stream, please reach out to avproduction@pccarx.com. Again, avproduction@pccarx.com, and our team there should be able to support you with any issues that you have. You'll also see a phone number across the bottom of your screen. That's for you to text in questions, should you have any. Throughout the presentation, please feel free to text in questions. That gives our moderators an opportunity to review them and prep them so that at the end of the presentation, as time allows, that we can provide those answers to your questions there. Lastly, I would encourage you to go to the PCCA website and visit the COVID-19 Resource Center. It's there for you. There's numerous tools that are available to you, from collateral that you can print out and put in your pharmacy to templates, several resources that we're going to talk about even this evening. We're updating that every single day, and it's there for you and for your staff. We encourage you to spend some time and take a look at it. Right now, I would like to introduce my good friend and colleague, Grace Stevens. Grace leads the HR team here at PCCA. Grace, I'm going to go ahead and turn it over to you now. Thank you.
Thanks, Ethan. Hi, my name is Grace Stevens. I work with about 5 HR team members. We're able to support you all as members. We have a benefits specialist. We also have an HR generalist who does a lot with compensation and talent management, so recruiting. And we also have a function of training and development as well. So we are able to give you guys access to that if you have any questions. I have the pleasure of introducing Charles Wilson. He is a shareholder for Littler Mendelson, and he has been working for PCCA for over 10 years and also has employment law experience for well over 20 years as well. So we're excited to have him here to share with you some of the information having to do with COVID-19 and the Families First Coronavirus Response Act. All right, I'll turn it over to Charles.
Thank you very much. I appreciate it. And thank you all out there joining us by video. For the next 15 minutes or so, I'm going to talk to you about the hot off the press law, the Families First Coronavirus Response Act. And then we'll take some questions afterwards. All right, so first and foremost, as we know, March 18th, Congress put into law this new statute. It takes effect on April 1st, and there are 2 components to it. There's an Emergency Paid Sick Leave Act component, and then there's the Emergency Family Medical Leave Act expansion, if you will. The first part is going to be called EPSL, that's Emergency Paid Sick Leave, and then the second part we'll call FMLA Plus. Now, a couple of things you need to know right now, and these are questions we get, or we've been getting the last few days. This new law is not retroactive. It begins or takes effect April 1st, which is 2 days from now, and it sunsets December 31st of this year. If you're covered by this new law, the Families First Coronavirus Response Act, you have to post a poster. And I've shown some links in the presentation where you can get a copy of that poster, and you post it wherever you normally post notices of this kind. It could be a break room, it can be a common area by a time clock. Given the fact that a lot of your workforce, if it hasn't been doing this before, they're probably going to be teleworking. I always say, hey, throw it up on your intranet, or send it by a mass email to all of your employees. That's another good way to post it. In addition to that, there are some resources online from the Wage and Hour Division of the Department of Labor. I've included 2 links there in the presentation. That very last link was updated on Saturday night, March 28th, by the way, and that's a very good resource for you to consult. There are about 58 questions in that link that the Department of Labor answers for you about this new law. So that's a very good source of information to get started. Some other good news, or some other interesting points. This new law, by the way, was enacted by Congress. Congress gave the Department of Labor the right to not only enforce it, but to interpret certain provisions in it, which we'll talk about. And in terms of enforcement, the Department of Labor has specifically said, hey, employers, we're going to give everybody a 30-minute grace period. Now, we were asking, okay, well, when does this 30-minute grace period start? Does it start on April 1st when the law starts? Well, no. We don't get the 30 days grace beginning on April 1st. We actually, according to the Department of Labor, that 30 days starts March 18th and ends April 17th. So we're really getting 17, maybe 16 days of a grace period. But the good news is that, hey, if you can show the Department of Labor that you, in good faith, tried to comply with the new law, that you didn't violate the law willfully, and that you will commit in writing, if you will, that you're committed to complying with the law in the future, then they're going to give you a pass. They're not going to seek an enforcement action or an enforcement investigation against you, which is good. Now, that is no guarantee against private litigation. So there's still a chance that private litigants or private lawsuits can be filed against you as a company if you violate this new law and it applies to you. Let's go over a general overview. As I said before, this new law, the Families First Coronavirus Response Act, has 2 components to it. There's an emergency paid sick leave component, and then there's an emergency paid FMLA component, or FMLA plus. The first component can pay you, or you're supposed to be paying your employees up to 80 hours for qualifying reasons. There are 6 qualifying reasons. And depending on the reason, that's going to determine how much you pay the employee. So there's 6 reasons, as we'll get into, that you're going to have to pay an employee paid sick leave. The Emergency Paid Family Medical Leave Act, or FMLA Plus, kicks in generally days 11 through 60, or weeks 3 through 12. And there's only one reason you can take FMLA Plus as an employee, and that is to care for a child that's 18 years or younger, your child, that you have responsibility for, because that child's school or daycare facility has closed for a COVID-19 related reason. And in that case, you get certain benefits. And the benefits vary. Some employees will get 100% of their pay for certain periods of the leave, and then for other reasons, they'll get 2/3 of their pay. Now, let's talk about the Emergency Paid Sick Leave Act. The first 80 hours is what you need to pay your employee. Every employee you have on the books is eligible to get this benefit. If you've just hired them, they're eligible. It's available for immediate use regardless of how long the employee has been employed. The only caveat is that this benefit is capped at 80 hours, which can be taken in the first 2 weeks of leave, or, as we'll talk about, it can be taken intermittently under certain circumstances. Now, you compare that to FMLA Plus. For that benefit, again, there's only one reason you can get that particular type of benefit. For FMLA Plus, the employee has to be employed with the employer for at least 30 days before the request is made. So that's the main difference there. Now, I told you before that there are 6 reasons in the statute that qualifies an employee to take either emergency paid sick leave or FMLA Plus. Really, there's just 6 reasons for emergency paid sick leave, and those reasons are that employee is subject to a federal, state, or local quarantine or isolation order that's related, in this case, to COVID-19. Another reason is the employee is advised by a healthcare provider to self-quarantine because of COVID-19. The employee is actually experiencing COVID-19 symptoms and is seeking medical treatment or diagnosis. And then reasons 4, 5, and 6, well, really reasons 4 and 5 focus on caring for others. So reason 4 is triggered when the employee has to care for an individual who is either subject to a quarantine order or has been advised by a healthcare provider to self-quarantine, i.e., maybe your parents or someone else that you might have a responsibility to take care of. And then the 5th reason is the child care reason. If you have a child, son or daughter, whose school or place of care or child care provider is unavailable due to COVID-19 precautions, then that will also trigger either emergency paid sick leave or FMLA Plus. And then reason 6 is sort of like a catch-all. And that reason states or reads, the employee is experiencing substantially similar conditions as specified by Health and Human Resources, or Health and Human Services, excuse me. And so we kind of think that was thrown in there just in case there's either another type of related pandemic occurring, or maybe there's some other precaution that needs to be taken that the U.S. Health and Human Services will step in and say, hey, we now need to do this. So that's what that's in there for. Now, remember, I just told you a few minutes ago, for FMLA Plus, there's only one reason you can take that type of leave. The leave where you have to take care of a son or a daughter because that son or that daughter's school or child care facility is unavailable or closed for COVID-19 related reasons. If that employee, because of that unavailability of that school or child care facility, is unable to work or even telework because of that, and they have to take care of their 18-year or younger child, they get to have, or they're eligible for FMLA Plus leave. Now, what are the caps? So in both cases, you will have to pay for some level of leave, but it's capped. Reasons 1 through 3, which, if you can think of it this way, those deal with the situations where the employee is subject to a quarantine order, has been told by a healthcare provider to quarantine, or is actually experiencing symptoms that he or she is seeking a medical diagnosis for. They're going to get what's called Emergency Paid Sick Leave Act pay at 100% of their wages, capped at $511 per day, for a total of $5,110. But remember, I also said for emergency paid sick leave, you can get 2/3 of your pay for reasons 4 through 6, and that benefit is capped at $200 a day, or $2,000 total. The FMLA Plus benefit doesn't kick in until weeks 3 through 12 in general. And again, FMLA Plus is limited to reason 5, which is childcare for COVID-19 related reasons that results in the unavailability of the school or the child care facility. So here's a question: how do I figure out how much to pay my employee? Well, it's somewhat straightforward. There might be some questions when you get to part-time employees, but for full-time employees, their emergency paid sick leave benefit is up to 80 hours, or approximately 2 weeks. And again, you just applied a straight cap. For FMLA Plus, it's up to 12 total weeks, but only 10 weeks are paid under this provision. And what that means is, as I said before, that first 2 weeks, you have, or the employee could get FMLA Plus, but it's unpaid. But in reality, or as a practical matter, emergency paid sick leave is going to take care of the first 2 weeks anyway. And then you're paying them 2/3 of their pay. The part-time employee, you get to average the number of hours that employee has worked in a 2-week period, the most recent 2-week period of a normal schedule. If you still can't get a good average because the work schedule varies widely for that employee, you can go back 6 months and come up with an average in order to determine the amount of the benefit. And in any case, your floor is going to be the regular rate prescribed by the federal government, and then in those states that might have a higher regular rate, you go with the higher rate. Now here's another question. Some clients ask, hey, what if we already provide very generous time off benefits or paid time off or PTO? That's great. You can pay, well, let me back up here. Emergency paid sick leave and FMLA Plus are in addition to what you're already doing or what state or local law requires you to do. So if you're in a state or city that requires certain paid leave benefits, employees are going to get that as well. The one caveat or one thing to pay attention to is that you cannot force an employee to first take paid time off that is accrued but not yet been used. This benefit under the Families First Coronavirus Response Act gets priority. They get to take this no matter what. Now you can allow your employee, totally at the employee's option, to take paid time off to supplement what they're getting under the Families First Coronavirus Response Act. For example, if they're getting 2/3 of their pay, they can use at their election their PTO time that they have accrued to make up the difference, but you can't force them to do it. And as we'll get into a little later on, your tax credit that you might be able to claim as a business eligible or covered by this new law is limited to what you can actually pay to employees under the act. So if you pay them anything extra, such as the accrued paid time off, because you want them to be paid 100%, you're not going to get a tax credit for that extra 1/3. All right. Here's a question that I've been getting a lot the last few days. Can emergency paid sick leave and FMLA Plus be taken intermittently? And here's a general roadmap to that. Yes, while teleworking. So if you have a segment of your workforce, maybe it's a sales employee or some other back office function that can telework, and that person is not completely unable to work for one of the 6 reasons that we just talked about, but has some flexibility, then you can agree with the employee that they can take the emergency paid sick leave or the FMLA Plus benefits or leave intermittently. In the non-teleworking situation where they have to come in and work at a work site, the only way you can allow intermittent leave would be for reason 5. And that's where the child care or the school is closed. And the rationale for that obviously is to keep employees safe and to keep them from spreading the virus. All right, so we briefly touched upon it. Documentation. If you're familiar with the Family Medical Leave Act, you as an employer get to require the employee to provide you with documentation showing that they are eligible to take the leave. Well, the same thing is true here, except that it might be somewhat relaxed in a way. So you can require, and you should require, by the way, that the employee provides you with some type of appropriate documentation supporting the leave. That means the employee has to state his or her name, what's the reason for requesting leave, and it should match one of the 6 reasons we talked about. There should be a statement in the documentation somewhere that the employee is unable to work and to what extent. Like if the employee is totally unable to work, including teleworking, that needs to be put into the note. And then the dates that the employee is going to need to be on leave. So for example, if the employee has gone to a doctor and the doctor has advised that he or she needs to self-quarantine for 14 days, then that should be in the doctor's note. And by the way, I'm telling clients, hey, in today's age and technology, doctors should be able to send that to you via email, or the employee can as well. You can also use as documentation a copy of the quarantine or isolation order from that employee's local government. So you might notice that there are various shelter-in-place rules or ordinance orders in place. Houston has a stay-home, work-safe ordinance, or some other states call it sheltering in place. Though that might be the type of isolation order or note. If the school, your child's school, reaches out to you by email, I actually got an email from my kids' schools telling us, hey, they're going to be closed until April 13th. So you can forward that email, or your employee can forward that email to you, and that's going to be sufficient documentation triggering the right to leave. Now let's talk about some other questions. Some clients say, hey, Charles, I heard somewhere employers under 50 employees are exempt. And that's actually a very good question. When I read the law itself, the statute enacted by Congress says this law doesn't apply, or employers with less than 50 employees are exempt from the law. And that to me made sense, because if you remember, the FMLA applies if you have 50 or more employees within a 75-mile radius of a work site. Under this law, this emergency law, if you will, that 50-employee threshold is somewhat relaxed. And the DOL, the Department of Labor, has clarified that 50-employee or less than 50-employee exemption will only apply for reason 5. If you have, as an employer, less than 50 employees, and the employee is claiming that they need to take leave for childcare purposes that are COVID-19 related, that's excluded or exempt from the emergency paid sick leave and the FMLA plus benefits. That also means for the other reasons 1, 2, 3, 4, and 6, even though you might have less than 50 employees, according to the Department of Labor, you still have to offer those benefits to the employees. And by the way, let me back up. If it's also not enough for you to claim an exemption for reason 5 if you can. You also have to have an officer in the company certify, hey, it's going to cause substantial business expense and financial hardship, or jeopardize the financial health of the business, or there are not enough other employees that are capable or skilled enough to handle the functions of the absent employee. So somebody within your organization has to certify to that. And you just need to write that down, or be prepared to show the wage and hour division if they come knocking. But I think the big takeaway there is that the Department of Labor's position is that the only way you can claim an exemption for having less than 50 employees is if the employee seeking leave requests that leave for reason 5, for childcare purposes, because the daycare or the school is closed for COVID-19 related reasons. So here's another question. Wait a minute, Charles, I also heard that healthcare providers and emergency responders are exempt, meaning that they can be excluded from the paid leave benefits under the Families First Coronavirus Response Act. And that's actually true. So the Department of Labor clarified, in addition to what I just talked about, and said an employer can exclude from these benefits anyone employed at a doctor's office, anyone employed at a hospital, a healthcare center. And then it provides this long list that's in the presentation. And then I see the word pharmacy, and I've underlined it and I've bolded it. So anyone employed at a pharmacy, according to the Department of Labor, is exempt from this law. So then I get the follow-up question. So Mr. Wilson, does that mean we can exclude or not, we don't have to pay these benefits to all of our employees because they're all employed by, my pharmacy? And according to that language, it appears to me the answer is yes. You would be excluded, or that your employees would be excluded, which means under that very broad definition, not only pharmacists and pharmacy techs, but also your back office folks, your sales folks, anybody else that's employed by the pharmacy would be exempt. But here's the question, should you do that? That's going to be the next question for you. That's a business decision for you to make. And I tell clients, you're going to have to weigh that, which is not entirely a legal issue. You might have to say to yourself, it's better for us in the long run to go ahead and offer these benefits, even if it makes it somewhat, uncomfortable in the short run, because I want to be able to retain talent. Where are these people going to go if we don't incentivize them to stay, not only stay with us, but to do safe things so that the virus isn't spread to others. And then I can end up, or my business can end up not having those individuals in the future, because I can tell you that there are other companies out there that are thinking about this and saying, well, you know what, we're really busy right now, or we're going to be very busy, so we'll go ahead and pay our folks and pay our new candidates this benefit, even though we're under the 50 employee threshold, or even though these employees are all employed by a pharmacy. So that's something to think about there. Let's do a quick note on the tax credits, because I know that that's also something of interest. And quite plainly, written into the law is a provision that for every dollar you spend towards paid leave, whether it's emergency paid sick leave or the FMLA plus leave, you get a dollar for dollar tax credit. And you get to immediately recoup that or realize that by keeping back a portion of your FICA deposit, your employer payroll taxes that you would normally pay. So you need to get with your payroll folks. If you've decided that, hey, we're going to go ahead and pay our folks this benefit, or you're otherwise eligible, you need to get with your payroll folks and figure out a way of not only how to earmark the leave that's being taken, but also figure out a way to document, how to realize the tax credit. And by the way, if for some reason your pharmacy has 500 or more employees, whether, because of there are 500 or more employees with the company by itself, or you have affiliated entities that are under common integrated control, you might say to yourself, hey, I have more than 500 employees. This law doesn't apply to me, but I'm going to go ahead and pay it anyway because I want to incentivize people to stay with us and be safe and all other good stuff. And then I'm also going to try to realize the tax benefits. Well, you're not going to be able to do it in that instance. You can only realize the tax benefits by paying for the paid leave if you are an organization with less than 500 employees. So just keep that in mind as well. And by the way, as an aside, if you're also thinking, well, this is going to be really hard for me financially, remember the CARES Act, which was enacted on Friday. That's going to provide another opportunity for you to potentially apply for a forgivable loan to protect your payroll. Now, to navigate all of this, what I just talked about, you can consult your local labor and employment lawyer. Watch the Department of Labor's website and the IRS website as well for updates. Our firm has complimentary COVID-19 employer resources, and I've included a link in the presentation for you as well. And so those are all good places to start and keep up to date with changes as they occur in the law. And with that, thank you very much. I'm going to turn it back over for questions.
Yes. Thank you, Charles. Okay, so we have several questions in the queue. One being that the date, April 1st. So there have been people to say that they've heard from various places that the law was effective on April 1st, but at some places they say the 2nd. Which one is right? Which one is wrong? Which one do we have to go off of?
I think you go with April 1st. The Department of Labor is taking the position that it starts April 1st, even though the law says April 2nd is the effective date. Since the law also gives the Department of Labor authorization to implement certain guidance and regulations, just go with April 1st.
All right.
And it's not an April Fool's joke. It's really April 1st.
Perfect. Okay. Another question that we had that you already addressed, but I'd like to just reiterate, the companies with less than 50, what if they have less than 25 total employees? How does that work with this law? Are they exempt? What does that look like?
Yeah, so the answer is going to be the same as what I talked about before. The threshold is fewer than 50 employees. So if you have even less than 25, that might make it easier for you as a company to demonstrate the financial hardship that you would have to demonstrate for purposes of a reason 5 leave. But the Department of Labor still expects you, very small employer, to pay your employees for, if they have to self-quarantine and be away, if they have the symptoms and have to seek medical treatment or diagnosis. The Department of Labor is still taking the position that these benefits that have been enacted by law are absolute for the employee if, for example, they're employed, or if they've been there for at least 30 days, they can get Reason 5 benefits as well. So unfortunately, really, you can only say, hey, it's financially hard and difficult for me to pay somebody that's going to be out for childcare, COVID-19 related reasons, but not for anything else.
Okay. And in the ESPL or EPSL, is that in addition to the employee's existing sick pay? And when, as far as the sick pay, can it kick in? Can they use the sick pay before? How does that work?
Yeah, so let's talk about sick pay. So when we say sick pay, it can be two different things. It can be the sick pay that you as an employer provide as a benefit or paid time off. Sometimes it's referred to as paid time off or sick pay, or you might divide it into vacation pay and sick pay. That's fine. However you provide it, great. You cannot force the employee to take that leave first before taking advantage of the emergency paid sick leave or the FMLA plus benefits. You have to give them those statutory benefits first, and then you can give the employee the option. You can't require them to take paid time off to cover other absences. So it's entirely up to the employee whether they get to burn through that other paid leave.
Okay. And another question I have here is, what if our pharmacy is closed to public because of the prevalence of the virus, and they're not allowing any employees who've taken public transportation? Could that employee still apply for the leave?
Yeah, so that's a good question there too. I think it's also going to depend on whether there is some mechanism to telework for some folks. We might need to keep in mind this is still a moving target as well, and I think the Department of Labor is going to come up with another Q&A or set of Q&As that will address that problem, because we are seeing a few instances of that here and there. So I would say that if you cannot do the job of a pharmacy because you're closed, obviously, then to me that means you should qualify for the exemption, even for Reason 5 reasons, because you just can't do the work at all. And in that instance, as I talked about before, that should help make the case better, not only for the exemption under this new law, but also for, the payroll, if you will, that payroll Protection Act under the CARES.
Okay. And what keeps all of my employees from taking 2 weeks sick pay leave starting April 1st, since we are a shelter-in-place city?
Yeah. That's another good question as well. I think that if you are working in a shelter-in-place location, you're going to have pretty much all of your employees taking time away from the work site unless under that shelter-in-place law, you're considered an essential business. So keep that in mind too. If you look at the law, the local law, if you're an essential business as defined by that law, then it doesn't matter that you're closed or that the employees are subject to it. If your business is considered essential, you can still be open and operate, and then you can still require your employees to show up for work, whether that means at the site or remotely or teleworking.
Perfect. And to confirm, a pharmacy would be considered an essential business.
Yes. Most of the shelter-in-place orders I've read have a carve-out under the essential business umbrella that includes a pharmacy or some related medical providing facility.
Perfect. And can you further define quarantine order? We have someone that's located in Pennsylvania.
Yeah, so I don't have the specific definition under Pennsylvania law. I'd be happy to chat directly about that later. But for purposes of the federal law, it seems to me that it broadly will include a local quarantine order. So if you have an order from a local municipality or even from the state that says or requires certain employees to self-quarantine, or even from that state's Department of Health, is telling a segment of communities to self-quarantine, you can use that to trigger, or the employee can use that to trigger rights or paid leave benefits under this new law. That counts as the documentation. Now, the other key part too that I didn't really emphasize a lot is that they still have to be unable to work in order to get these benefits that we're talking about. So even though you might have, let's say in Pennsylvania, a shelter or a self-quarantine order, we'll just call it, it says self-quarantine, you have to self-quarantine, but this employee has a type of job where they can do it from home, either because they're in sales, for example, or there's some other function that they're allowed to telework, then they're not going to be able to say that they are unable to work. They need to have a healthcare provider say, hey, this person is unable to work even remotely for these reasons that are COVID-19 related in order to take advantage of the paid leave benefits in that situation.
Okay, I have one last question for you, Charles. So if we have someone who does want to implement this guidance in their pharmacy to cover their employees, can they pay for them to do this and still have them work since they're an essential business?
Yeah, so the answer to that, I think the short answer is no. If they're, well, it depends on the reason. So if they are, again, under a self-quarantine order, I'll use that as an example, which basically means, or it can mean, hey, I've been told by a doctor or I've been told by my local government that I need to self-quarantine for X amount of days. They can still work from home, potentially, depending on what the function is. So they would not be eligible for the benefits that we're talking about under this new law until it can also be documented by the employee that they are unable to work even remotely or teleworking. So that's going to be the key there.
Perfect. Well, thank you so much, Charles, for joining us today, and I'll go ahead and pass it on over to Ethan.
Thank you, Grace. And Charles, we appreciate your time today. We thank you for being here, for bringing your expertise. We know that there are several other questions, and as time hasn't allowed us to, we won't be able to get to them right now, but we will work through them and respond to those questions as they have come in. So we want to thank all of you for being here, for joining us. We hope that this was of benefit to you, that we brought you value this evening. A couple of just quick notes as we close our time together. If you have any future suggestions for topics that we should be covering on this member briefing each Monday night, please text those in. Again, as we have content, we will bring it to you, or we will forego that depending. But if you have something that you would like us to discuss and to share with you, please let us know. Number two is that the recording for this will be made available to you in the next day or so. We will have both the slides that Charles shared, as well as the full video available to you so that you can watch that or check back with that and click those links there. The links that Charles did mention, those will be available, or I believe they're actually already available on our Member Resource Center on the PCCA website. And lastly, I want to invite you to join us this Wednesday at 8 a.m. Central for the Marketing and Sales Power Hour. We're going to be covering and discussing how to promote your pharmacy in this very different time. So with that, we want to wish you all the best. We thank you for being here. Let us know how we can help you. Stay safe and have a good night.